The year 2025 saw a significant National Guard deployment in Washington, D.C., beginning in mid-August. This deployment grew to between 2,000 and 2,600 personnel, drawing from both the D.C. Guard and units from multiple states. Its presence was extended through late 2025 and into early 2026, sparking considerable legal and political debate. Initial deployments commenced in mid-August 2025. These units were tasked with patrolling federal areas and protecting key sites across the nation's capital. The mission's scope and duration quickly became subjects of intense scrutiny. A critical incident occurred on November 26, 2025, when a shooting near the White House involved Guard members. This event intensified calls for additional troops and further complicated the deployment's public perception. Throughout December 2025, federal court litigation and appeals challenged the legality of the deployment. An appeals court ultimately stayed a lower court order, temporarily allowing the Guard to remain while legal proceedings continued. The deployment included personnel from the D.C. National Guard and out-of-state Guard units. These units were authorized by governors of multiple states, with command and activation in D.C. flowing through federal channels due to the district's unique status. Troops performed patrols, secured landmarks, and provided various support tasks. Reported totals ranged from approximately 2,200 to 2,600 personnel at peak strength. Many soldiers originated from 10 or more different states. Units began arriving in mid-August 2025, with the presence formally extended through late 2025. Official orders further extended some activations into February 2026, even as litigation over the deployment proceeded. These dates reflect official extensions and public reporting, not a single continuous order. D.C.'s Attorney General, Brian Schwalb, sued to block the deployment. A federal district judge issued an order limiting the Guard's presence. However, the D.C. Circuit Court of Appeals paused that order, allowing the Guard to remain while the appeal continued. The appeals panel emphasized D.C.'s unique federal status in its reasoning for this decision. Several key players were central to the 2025 National Guard deployment. D.C. National Guard leadership managed operational command on the ground and administrative extensions. Out-of-state governors authorized their state's Guard units to deploy to D.C. voluntarily. Department of Defense and White House officials coordinated federal aspects of the mission. They also managed public safety emergency declarations. D.C. Attorney General Brian Schwalb and federal judges brought and adjudicated the legal challenges to the deployment. The deployment raised profound constitutional and federalism questions. These concerned the use of Guard forces in a federal district and the application of posse comitatus and the Insurrection Act. Specifically, it questioned when federal forces support law enforcement. Congress, federal courts, and state executives all played oversight roles. Litigation and hearings continued as the deployment was extended, highlighting ongoing debates about civil-military balance and governmental authority. On November 26, 2025, 2 National Guard members were shot near Farragut West. The deceased was Specialist Sarah Beckstrom, and Staff Sergeant Andrew Wolf was wounded. Ramanullah Lakanwal was accused, arrested, and now faces federal charges and investigation. Specialist Sarah Beckstrom was a National Guard member who tragically died in the incident. Staff Sergeant Andrew Wolf was a National Guard member who sustained injuries. Ramanullah Lakanwal is the accused shooter, arrested and charged in connection with the event. U.S. Attorney Jeanine Pirro was the federal prosecutor who moved the case to federal court. Federal investigators and local law enforcement, including the FBI and Metropolitan Police, led the probe into the shooting. The incident was an ambush-style shooting near Farragut West Metro, 2 blocks from the White House. It resulted in 1 Guards member dead and another critically injured. The accused was shot and subsequently taken into custody. The critical date of the attack was November 26, 2025. Local charges were filed quickly following the incident. Prosecutors later moved the case to federal court where the death penalty could be considered. This move signaled significant federal interest and the application of broader prosecutorial resources. The federalization of the prosecution means federal statutes and resources, such as the FBI and the U.S. Attorney's Office, drive the investigation and charging decisions. Civil rights or civil liability claims by victims or families remain possible, but these are separate from the criminal prosecution. Operational oversight of the D.C. National Guard is exercised through federal channels. The District's Guard answers to the President and Department of Defense authorities. Investigations and prosecutions are handled by law enforcement agencies and the U.S. Attorney's Office. Policy and accountability originate from the Department of Defense, Congress through oversight hearings, and federal courts when legal disputes arise. Criminal charges are decided by prosecutors and adjudicated in court. Criminal prosecution is the primary public action taken so far involving federal charges and the detention of the accused. Civil claims, such as wrongful death, negligence, or constitutional claims tied to the broader Guard deployment, are legally possible. Public reporting to date focuses on criminal charges and the federal investigation rather than a catalog of civil suits. Harassment allegations against personnel or families have been reported in some high-profile incidents historically. However, specific, verified claims tied to this shooting require case-by-case documentation from court filings or news reports. Future developments will be closely monitored. These include prosecutorial filings and court docket entries in federal court for charging documents and motions. Department of Defense and congressional oversight reports will be important if questions arise about Guard posture or rules of engagement. Civil filings by victims' families will also be significant if and when they are publicly filed. The January 6, 2021 attack on the U.S. Capitol produced multiple deaths, dozens of injuries, widespread theft and property damage. Hundreds of criminal prosecutions followed, many resulting in prison terms. Extensive congressional and Department of Justice investigations produced reports, prosecutions, and later political and legal controversy. Several civilians died on or immediately after January 6th, including Ashley Babbitt. At least one officer died shortly afterward. Later officer suicides and medical complications have been linked to the event. At least 174 law enforcement officers reported injuries from assaults and chemical exposure during the breach. Rioters ransacked offices, stole items from desks such as pens, laptops, and souvenirs, and caused millions in repair costs. Individual theft prosecutions followed these incidents. Over 1,500 people were charged in federal court, with many guilty pleas and hundreds sentenced to incarceration before later pardons or commutations in 2025. The official tallies and legal outcomes evolved over years as prosecutions, appeals, and political actions unfolded. Individual rioters and organized groups, such as the Proud Boys, Oath Keepers, and other extremist cells, were charged with assault, conspiracy, seditious conspiracy, theft, and obstruction. Leadership prosecutions produced long sentences for some members. Law enforcement, including Capitol Police, Metropolitan Police Department, and federal partners, bore the brunt of physical assaults. The Guard's role was primarily support and perimeter security in many instances. However, the command and timing of Guard deployments became a major oversight issue. Members and staffers' offices were ransacked and items were stolen. Many victims later sought restitution, and some items were recovered during investigations. Dozens of high-profile defendants, including leaders of extremist groups, were convicted of conspiracy and related felonies. Sentences ranged from months to decades for seditious conspiracy convictions. By late 2024, the Department of Justice reported hundreds of guilty pleas, many trials, and numerous sentences. The Department of Justice's resource page and the House Select Committee produced timelines and evidence used in prosecutions and oversight. Appellate and Supreme Court rulings, including limits on certain obstruction charges, altered sentencing and charge strategies. This produced resentencings and dismissals in some cases. Many defendants received prison terms following criminal convictions and sentences. Some convictions were later affected by appellate rulings and by the 2025 presidential pardons that commuted or erased many sentences. This prompted further litigation and Department of Justice adjustments. Families and victims pursued civil claims in some cases. The Department of Justice and other agencies also paid or settled certain claims tied to deaths and injuries in the aftermath. Many individuals were charged for crimes related to the January 6, 2021 attack on the U.S. Capitol. Prominent prosecutions included leaders and members of the Proud Boys and Oath Keepers. They were charged with seditious conspiracy, obstruction of an official proceeding, assault on officers, theft, and related felonies. Enrique Henry Terrio faced charges of seditious conspiracy, conspiracy to obstruct an official proceeding, and destruction of government property. Cliff Biggs and Zachary Rail were charged with seditious conspiracy, conspiracy to obstruct an official proceeding, and civil disorder. Dominic Pisola faced charges of obstruction of an official proceeding, destruction of government property, and assault and robbery involving government property. Stuart Rhodes, the Oath Keepers founder, was charged with seditious conspiracy, conspiracy to obstruct an official proceeding, and related felonies. Kelly Meggs, an Oath Keepers leader, faced charges of seditious conspiracy and conspiracy to obstruct an official proceeding. Oath Keepers associates Roberto Menuda, Joseph Hackett, David Murashel, and Edward Vallejo were also charged with seditious conspiracy and conspiracy to obstruct an official proceeding, with Hackett also facing destruction of evidence charges. Prosecutors used statutes including seditious conspiracy, obstruction of an official proceeding, civil disorder, assault on federal officers, and property damage/theft statutes. These were applied to charge leaders and participants who allegedly planned, coordinated, or executed violent or obstructive acts at the Capitol. Federal authorities charged over 1,500 people in connection with the attack. Prosecutions ranged from misdemeanor trespass to multi-defendant conspiracy and seditious conspiracy trials, producing hundreds of convictions and sentences before later political developments affected some outcomes. Leaders convicted of seditious conspiracy received lengthy sentences, some measured in years. Many lower-level defendants pleaded guilty to obstruction, trespass, or assault and received varied sentences, probation, or fines. Appeals and legal developments have altered some sentences and charges over time. Donald Trump has faced 4 major criminal prosecutions since 2023. These include a New York State hush money case, 2 federal cases concerning classified documents, and 2020 election-related matters, and a Georgia state election interference case. Each case involved different prosecutors, judges, and legal issues. The New York hush money case charged Trump in March 2023 in Manhattan with 34 counts of falsifying business records tied to a 2016 payment. He was convicted by a jury on May 30, 2024. Sentencing occurred on January 10, 2025, with an unconditional discharge entered by the trial judge, followed by appeal activity. The federal classified documents case in Florida indicted Trump in June 2023 in the Southern District of Florida. Charges related to the retention and obstruction concerning classified materials. Judge Eileen Cannon dismissed the case on July 15, 2024. The special counsel office later withdrew its appeal after the 2024 election outcome. The federal 2020 election interference case in D.C. indicted Trump on August 1, 2023. Charges included conspiracy and obstruction tied to the January 6 certification. Litigation over presidential immunity and prosecutorial scope produced Supreme Court guidance. The special counsel later moved to dismiss following the 2024 election result. The Georgia state election case in Fulton County indicted Trump on August 14, 2023, on state charges related to alleged efforts to overturn the 2020 Georgia results. The prosecution faced procedural challenges and leadership changes. The new Fulton County prosecutor dropped the case on November 26, 2025. A Supreme Court immunity ruling in June 2024 narrowed the scope of prosecutable presidential acts. This affected the D.C. case and prompted further briefing and adjustments by prosecutors. Post-election prosecutorial decisions also played a role. After the 2024 presidential election, federal special counsel offices altered or withdrew prosecutions in light of Department of Justice policies and political transitions.